My name is Michael Burgis. I'm a legal certified specialist in California workers' compensation. I'm the managing attorney of MB&A. And what I want to go over with you is some recent case law. In this case, it's Wachiuri versus Torrance Memorial Medical Center. This is a case that came out in June of 2018 and is really dealing with a very specific issue, and that is communications to a QME or a panel QME or what's called an agreed medical examiner. But essentially it's this case is governing communication to a neutral doctor. Before you watch this video or after you watch this video, I recommend you watch a video on Sandab Suon versus California Dairies. It's fundamental in this area of law as well. But this case is essentially governing and adjudicating what communication you can have to a neutral doctor. And what happens is this. Client sees a treating physician, one of the parties object, and we get this neutral doctor. And we have to do a joint letter or respective advocacy letters to this doctor and saying, hey, here's what's going on in this case, here's what I want you to address. Now, what typically happens is shady defense attorneys, and by that I mean pretty much every attorney, a law firm, and insurance company on the planet, they all do this, okay? What they do is they write an advocacy letter to the doctor and they say, this is a denied case. We believe he filed it after he was told he was terminating. We think it's all bullshit, and try to frame the issue to make this doctor think that it's a bullshit case. Excuse my language. That's part of their job, and that's how they're advocating for their client to minimize their liability. Inversely, I often do advocacy letters where I show that everything they're saying is bullshit and then show them the true fact pattern, frame the issues in the light most favorable to my client, which is probably where the truth is. But be that as it may, the question here is regarding those advocacy letters. And I've always taken the position that those letters to the doctor that's not where you argue the factual basis. The factual basis or the issues regarding non-medical issues are for the trial judge, not the doctor. So I've indicated that they can never state their reason for denying the case or why they think the case is factually bullshit, because that's not relevant to the medical opinion, and if anything could unduly influence that opinion and cause detrimental impacts on a injured worker, especially if later those facts are determined to be inaccurate. And this really comes up a lot with like post-termination defenses, where somebody files a claim after they've been terminated, and so the defendant is arguing it's a post-termination defense, it's bullshit, the case is bullshit. This case, finally, the holding says a defendant can't do that. A defendant cannot lay out factual issues of why they denied it, because that's not proper for the medical physician. Now, the defendant can state that they've denied the case based on lack of medical evidence, and that's basically asserting to the doctor saying, hey, the only reason why we haven't accepted this, we don't have any medical evidence showing that it's an industrial injury. And the court is saying that's fine, that's appropriate, but you can't indicate to that doctor that it's denied because of post-termination or because there was a dispute, a factual dispute. And the defendant is not allowed to attach their denial letter, which is articulating those factual disputes. So this is a great case for injured workers. It's a case, the holding I've been arguing from day one, and essentially it states that it should be a really vanilla letter to these doctors, just really adjudicating the name of the client, who he worked for, length of employment. If there was a medical dispute, they can articulate that, but they can't put in factual disputes because that could unduly coerce this or cause bias for this physician. So the case is a very, very good case. And in addition to the additional case mentioned previously, the Maxim case is another good case if you're really interested in communicating to and from these neutral doctors. That distinguishes between communication and information, which can happen after the initial contact with that doctor. But that first initial contact, that joint letter, that advocacy letter, shouldn't delineate factual disputes, shouldn't attach denials based on factual disputes, and really is a good case for injured workers as it stops shady insurance companies via their defense attorneys or adjusters or their advocates, trying to unduly bias these neutral doctors to their favor. I hope that this has been helpful. If you have any questions or concerns about this case or anything else on my channel, feel free to give us a call. We have the answers and we're standing by. Thank you.